Hello, everyone, and welcome back to Introduction to Criminal Justice. Today, we'll be talking about constitutional restraints on the police. So, this is a very in-depth field. It's my field of preference. That being said, what you're going to get today is a very high-level overview. So, if you end up taking Criminal Law 1, which you will do if you do legal studies or if you do criminal justice, you will get a lot more in depth as to what your rights are, what the restraints on police are, things along those lines. So that being said, let's jump in. So if you recall from a previous lecture, we looked at the nature and function of police. Right, so police departments are composed of three divisions: the line services, obviously the police officers being the most visible part, administrative services, and auxiliary services. While there's no doubt that policing can be dangerous, most of an officer's duties are focused around peacekeeping, so traffic enforcement, service of court documents, minor infractions, dispute resolutions, etc. The criminologist James Q. Wilson articulated three styles of peacekeeping. The legalistic style, which remember is the more harsh, more if the law is broken, you enforce it, very little discretion style. Watchman style, there's a decent amount of discretion here. And then we have the service style, which emphasizes service to the community, and there is absolutely very far-reaching discretion. And we talked about how there's no one prevailing style in any given police department, right? Most of the police departments are going to be a mix of these styles around their needs. Now, that being said, many departments are adopting a community policing model, so starting to revert back to watchman and service style, that they will patrol beat, they know the people on their beat, they interact with them, they interact with the community, and so they're not seen as somebody who's necessarily a threat, but as someone that you can rely upon or somebody that you can know if you have a problem. So let's look at the overview of police powers. Police officers have a significant amount of power to investigate crime and make arrests. Police investigatory powers include the power to stop you, the power to frisk you, the power to issue an exit order, the power to question, and the power to detain. Whereas police arrest powers include the power to use reasonable force, the power to search, and the power to seize. So when we're talking about stop and frisk, generally we're talking about Terry stops. It came from a case, Terry v. Ohio, in which if the police have reasonable suspicion, and we'll get into this, they can stop you temporarily. Your Miranda rights do apply, though they don't have to be read. And they can frisk your outer clothing, right? And it's only supposed to be a brief investigatory stop. An issue or an exit order is if you're in your vehicle and they tell you to get out, you have to get out. Now, certain states have gone beyond that and given more protections. So, for instance, Massachusetts, there are very limited circumstances in which police can issue exit orders, whereas New York, there's very little in terms of restraint regarding exit orders. Again, we also have the power to question, right, so to interrogate and to detain. And then use of reasonable force, that's going to be dependent upon the circumstances, right, based upon the totality of the circumstances, what was reasonable in that situation. And of course, we have the power to search and the power to seize. Now, the federal government and sometimes state constitutions serve as a check on these powers for the protection of citizens. So these are all the police powers, the federal constitution, and then sometimes states, like we talked about with Massachusetts, serve as a check on these powers. Right? So granting you certain rights, not necessarily to help you get away with crime or something along those lines, but to ensure that key liberties we enjoy are protected. So let's talk about Fourth Amendment protection, search and seizure. So the Fourth Amendment, and there's a link to it if you want to read it, defines the right of citizens to be free from unreasonable searches and seizures. Now, the amendment protects, and this is directly from the amendment, persons, houses, papers, and effects. Now, the Supreme Court has interpreted this phrase very liberally to meet societal evolution, right? And the idea here is the founding fathers could never conceived of the internet or email, right? And internet, email, internet usage, does that necessarily fit neatly into persons, houses, papers, and effects? Not really, no. So this part of the protection has been liberally interpreted. Now, historically, the Fourth Amendment protected places, not people. Today, the Fourth Amendment protects people and not necessarily places. So anywhere that someone has an expectation of privacy is free from unreasonable search and seizure. So an expectation of privacy has two prongs. The first prong is subjective. So did that individual believe they had a right to privacy? And the second prong is objective. Would we as a society say that person's belief is reasonable based upon the circumstances? Now, both of these tests have to be met in order for us to say there's an expectation of privacy, and therefore that place, whatever is in question, cannot be subject to unreasonable search and seizure. Now, if a person doesn't have an expectation of privacy, generally speaking, we can't call something a search. It's just kind of a legal formality, but you don't have a Fourth Amendment protection if you don't have a reasonable expectation of privacy, right? So police can do whatever is permissible within their authority if you don't have that expectation of privacy. Now, you're going to have the highest expectation of privacy, usually in your home. That's kind of, it's very sacred in the law. So if police want to cross the threshold into your home, they have to have a warrant or have some kind of exception to the warrant requirement. And we'll talk a little bit about that. So, Fourth Amendment says unreasonable search and seizures. What is unreasonable? Generally, this means extreme, arbitrary, or capricious. That being said, we presume that search and seizures conducted without a warrant are de facto unreasonable. Okay? So generally speaking, it's up to the prosecution once the defendant raises the issue. The prosecution has to prove why the search was reasonable under the Fourth Amendment, right? Or justified for not having a search warrant. With some of the justifications that we have, and we'll get into a little bit of detail in here, but definitely discuss later on. Now, that being said, if we look at the warrant requirement, right? So again, kind of going back up to the Fourth Amendment, warrants are required and are to have and are issued upon a finding of probable cause, right? So probable cause, if we think of a spectrum from 0 to 100, right, and it's a certainty spectrum. So we have 0% certainty and 100% certainty, right? Halfway point is 50%. All we need to issue a warrant is 50.01%, or 50% in the feather, however you want to describe it. Just that something is even the tiniest bit more likely than not, then you can get a warrant, right? So probable cause is actually a relatively low bar to meet, just slightly better than a coin flip. Now, how do we determine probable cause? Well, if we look at Illinois v. Gates, Illinois v. Gates tells us we look at the, quote, totality of the circumstances. So this idea is based upon everything that the officers knew or reasonably should have known. The circumstances suggest that there is probable cause, right? So this prevents this kind of arbitrary and capricious application of the Fourth Amendment. Really to the extent that when we think about probable cause or the totality of the circumstances, we look at legitimately everything that happened, right? And hindsight is 20/20. If you're in the moment, you might make a mistake. And we accept that fact as a part of daily life. That they might make a mistake and the evidence gets excluded under the exclusionary rule. But we rather evidence be excluded than somebody's rights be violated, right? That's kind of what we've really kind of started to accept as a society. So again, probable cause is determined by the totality of the circumstances, everything in the realm that officers knew or should have known. Now there are exceptions to this rule, and we'll get into those exceptions. So when can we conduct a search without a warrant? The first and one of the most common is a search incident to a lawful arrest. So various cases, and we'll talk about it in Criminal Law 1, have limited where police may search in terms of the person of an arrestee and his or her immediate grabbable area. Right, so police may search the person of the arrestee, so their physical person, their pockets, empty, step out of your shoes, all that jazz. And anywhere that's in the immediate grabbable area of that arrestee. And the idea is this way, the immediate grabbable area is basically somewhere you can lunge, right? And the idea here is we don't want a suspect destroying evidence or reaching for a firearm or something along those lines. So we can take a quick look around to make sure there's nothing that the arrestee can get a hold of. And this may occur inside of a home. We can't drag the defendant from room to room to search a home, saying it's an immediate grabbable area. No, generally speaking, we're talking right around this person's area. And then once they get put into the police car, search incident to a lawful arrest kind of terminates from the police side. That being said, once they arrive at the jail, they'll be searched again. And we also consider this a search to an incident or to incident to a lawful arrest. Now, again, in a jail setting, there's probably no real reason to look around the area because theoretically you haven't transported the evidence or weapons with the suspect. So that's a search incident to a lawful arrest. We also don't need warrants during, and I mentioned this earlier, Terry stops. You may refer to Terry stops as stop and frisks. So basically, according to the case Terry v. Ohio, it's a 1968 case. So this occurred during that criminal justice revolution led by Chief Justice Earl Warren. Officers may stop and frisk an individual if they possess what's called reasonable suspicion. All right. So think again of this scale from 0 to 100. If we have probable cause at 50.01%, reasonable suspicion is between 15 and 25%. Sure, that's that this person is up to no good, about to commit a crime, something along those lines. Right? So all we really require is an articulable reason. You can't just be like, well, they seem suspicious. Like, no, why? What were they doing? What made you think they were suspicious? Right? And when we talk about reasonable suspicion, race can be considered a part of reasonable suspicion, but it has to be one factor among many, right? So if officer is patrolling his beat and it is a historically all-white neighborhood, right, and there's been a rash of burglaries and somebody said they saw a black man run from one of the houses, and police are just driving, doing their patrol, and they see a black man walking down the sidewalk, that might be enough for them to pull over, take the black man, basically seize him for a second, frisk him, and ask some questions. Now, it can't go on too long because it's not an arrest, but the person's also not free to leave. Now, that would probably be okay, and there's actually cases that suggest that's okay, from a legal standpoint, I should say. Because the idea here is it's not we're just basing it upon the fact that this person is black, but that there's been a rash of burglaries, this is an all-white neighborhood, and a black man was seen running from a home. So maybe that's enough, right, to get us to that 15 to 25% sure something's going on. Now, when the officers conduct a frisk, generally speaking, a frisk is limited to the outer clothing, and it's designed for the purpose of discovering weapons, right? So if you're wearing a coat, it's designed, you pat down the coat, the pants, whatever. During the frisk, you do not go inside pockets. However, when we do a frisk, something called the plain field doctrine gets initiated. Under the plain field doctrine, if officers feel something that they essentially immediately know is a weapon, they can reach into the pocket and retrieve it, or wherever it's hidden and retrieve it. Right? And again, that's for the safety of the officers. They may also, during this frisk, go into your pockets if they feel something and they immediately know it's contraband. Right? So if they pat down your pocket and they feel what they immediately know is, okay, this is a dime bag of heroin, right? Which is kind of a hard bar to meet, but if they find it, if they immediately know this is contraband, they can reach into the pocket of this person that doesn't have a probable cause or anything like that, pull out the heroin, and that person can be charged with whatever they find during their frisk, as well as whatever derived from their suspicion to stop the person to begin with. Right? So that's the plain field doctrine. You have to kind of immediately know that it's a weapon, or immediately know that it's contraband, in order for you to go into the pockets or go into the waistband or wherever this thing may be hidden. Now, this is obviously very controversial, especially in New York City. New York City stop and frisks were primarily done upon African Americans. I mean, the vast majority were. And most of the time, nothing was found, right? So this triggered several lawsuits, and New York City kind of had to reform how it operates and has to keep databases and all that stuff regarding stop and frisks. So how do you know if you're being subjected to a Terry stop? The thing that you need to ask an officer, if an officer stops you, is ask, am I free to leave? If you are, then that's just an encounter and you can leave. Your Fourth Amendment right, or excuse me, your Miranda rights do not apply, right? So anything you tell an officer is a confession. And you can't be like, well, he didn't read me my Miranda rights. Well, no, you were free to go. You just decided to tell the person and not walk away. Now, if an officer says, no, you're not free to go, well, then you know one of two things is happening. Either one, you're getting arrested, or two, the officer is conducting a Terry stop. And the Terry stop is usually just to dispel the suspicion of the officer, or investigate what this person is doing, right? And Terry stops are only supposed to last a couple of minutes, if that. They're supposed to be very, very short, and it also kind of depends on the crime that they think might be occurring and things along those lines. Another exception is automobile searches. So pursuant to what's called the Carroll Doctrine, because automobiles are mobile, officers may conduct a warrantless search if they have probable cause. Right, so we've gone way back from the 15 to 25, and now we're back up to the 50.01%. Right, so if officers have a 50.01% certainty, or not certainty, belief that you are possessing contraband, or the contraband will be found in place X in your car, then generally speaking, officers can search it. Now, the idea behind here is you have a reduced expectation of privacy in your vehicle. Right? I mean, think about it. Your vehicle is surrounded by windows. And also, just as a practical matter, if we had to wait and get a warrant when we pulled somebody over, you would just drive away, right? Like you'd move the vehicle. So it's kind of a practical rule, but also notion of, look, everybody can see what you're doing inside your car. And if you have your windows tinted too much, well, that's illegal too, right? Partially for this reason. So this is kind of where we're at in terms of automobile searches. Now, there's a lot more that can come into play, such as inventory searches. You can actually stop and frisk a car, things along those lines. But that's a little bit too involved for this course. We'll get into that when you reach Criminal Law 1. Now, that being said, there was a recent case, it was a 2020 case, that came down and it said you can search an automobile, right, with probable cause, you don't need to get a warrant. The 2020 case said that's true unless the car is parked in a driveway. So if the car is parked in the suspect's driveway, you need to get a warrant, right? Because it's kind of presumed to be a part of the chattel, and chattel is just the legal term for area immediately surrounding the home, which is invested with a significant Fourth Amendment protection. Now, we've also seen things pop up, and this kind of relates to automobile searches, are roadblocks. So roadblocks pose a unique challenge. And we say this because if police set up a roadblock, right, let's say it's a DUI checkpoint, they generally are constitutional. Roadblocks, where they stop every car and check, right, cannot be undertaken to find criminal activity, right? So you're not trying to discover some kind of crime or somebody wanted, whatever. No. But you can do a roadblock for inspections, right? So part of your agreement with the state when you get a driver's license is you will adhere to not drinking and driving, right? So if we have a DUI checkpoint set up, theoretically, we're not there to catch criminals. We're there to ensure that you're not driving intoxicated, that you're safe, and making everyone else safe. Now, the reality is that's a little tongue-in-cheek because inspections and criminal issues are very much tied together, right? And if you've ever been through a roadblock, it is not a fun time. It's definitely scary, but you know, most of the time it turns out fine. And when you get to Criminal Law 1, you can learn about all the fine details of DUI checkpoints and what you can do, what you can't do, etc. Other warrantless searches, one is hot pursuit. So if officers engage in chases to prevent an escape or effectuate the arrest of a suspect, we don't require a warrant to arrest or search a premises, right? So the idea here is you're chasing a suspect. The suspect runs into a home, slams the door. Police, you remember the home is this really sacrosanct area. It would be unfair, it would be unsafe for the police to not go inside and instead wait to get a warrant in order to go inside. Just think about it. What if that felon wasn't their home? What if it was the home of somebody else? If they're fleeing, they might be dangerous. Right? So they might be in there and they might have like people at gunpoint or something along those lines, right, to negotiate with police. I'll release the hostages if you do X, Y, and Z. So we say hot pursuit, just keep going. Right? If he runs into that house, you run into that house behind him. And we recognize in this situation that we are violating the rights of the homeowner. However, most homeowners would agree that if a person who is fleeing from police, wanted by police, runs into your house uninvited, you probably want the police to go ahead and come on in. You probably don't want to say, oh, well, I don't want them to have a warrant. And again, unless you're doing something illegal, and then you probably want them to have a warrant. So that's kind of the balance there. Now, there's also something called consent searches, right? So consent search is if a person who is in control of an area or object consents, police can conduct a search of that area. I'll begin by saying never, ever, 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 never, ever, ever give consent for police to search anything, even if you know you have nothing. And I say this for a couple of reasons. One, most police officers are good, but there are some that are crooked. Police officers have been known to plant things before. And so if they're searching and they're not finding anything, that officer might reach into his pocket, pull out a little bag, and be like, oh, look what I just found. If they're trying to set you up, right? So don't do that. Also, how many of you drive used vehicles? If you drive a used vehicle, think about the previous owner, and you may know the previous owner, you may not. But let's say, have you taken the carpet in the back seat, like, or in the trunk area, and pulled it away from the window, right? Taken the clips off and pulled it away. If not, how do you know there's not drugs back there? Because police are going to search back there, and if they find those drugs, guess what you're going to say? Those drugs aren't mine. Guess what police hear every single day? Those drugs aren't mine. You're probably going to get charged with it. Right? So again, and if police are asking to search, it means they don't have probable cause. Right? They don't have enough to get a warrant. They don't have enough to just go ahead and search your vehicle. Because they wouldn't ask otherwise. They would just do it. Right? So this raises three key issues. The first issue is who can give consent. Generally speaking, anybody over the age of 18 can give consent to the search of their premises. Now, that being said, this has a caveat. Let's say you live with a roommate, and we're going to say that this is an off-campus apartment. Right? You live with your roommate. You're not home, but your roommate is. Police knock on the door and say, hey, can we search your home? And the roommate says, sure. And they search your home. And they find drugs in your room. Is this permissible? The answer is actually no. So what you can consent to if you're a roommate, if you share rooms, is any common area and any area that you control. So in the roommate example, the roommate could agree to a search of his or her room, as well as the common areas, right? So the living room, the kitchen, etc. But they cannot consent to a search of your room. Now, this gets a little bit more tricky when you get married. Under marriage, we presume that you have equal control over everything. However, we are seeing the emergence of man caves where the wife isn't allowed, or she sheds, or other areas where maybe a walk-in closet where the husband isn't allowed. In those instances, the police can only search where the person has control. So if, let's say it's a man and wife, and the man has a man cave and the woman isn't allowed in there, right? Which is just ridiculous. But if they did, they did. Police can search the entire house except the man cave, right? They would have to get consent from you or the husband to search the man cave. Now, can a minor give consent to search a house? No. But there is this idea of reasonable reliance. So if you don't live in a house, or you don't have authority over a house, the police come up and they say, "Are you John Smith?" and you lie to them, and they have no reason not to suspect you're John Smith, and they ask, "Can I search your house?" They can search your house. So careful who your overnight roommates are. If you give consent, it must be done so freely and voluntarily. So when talking about freely and voluntarily, basically we can't coerce you into consenting, right? Even something like, well, we can get a warrant, that's enough to be involuntary consent. That's enough to be coercive, right? And it should tell you, well, if you had enough to get a warrant, then why don't you have a warrant? So again, that's what constitutes free and voluntary consent. It gets real tricky if they put handcuffs on you or something like that. Like, can you voluntarily consent if you have handcuffs on? The idea is it's supposed to be like a non-punitive atmosphere. That being said, the police do not have to tell you you can say no. Right? So they're going to say, "Oh, I'm going to search this house. Is that all right?" They're asking you a question. You're just going to assume, yeah, like you wouldn't be asking if you couldn't do it, right? No, they don't have to tell you you can say no. And that's been a kind of a problem when it comes to free and voluntary consent. Is something really free and voluntary if you don't know that you can say no? Well, the idea here is, as a citizen, it's your job, it's on you, it's your obligation to know your rights at all times. Right? So you should know that you can just say no. And then again, the principle of limited consent says you can consent to a search, but you can tell the police where they can look and where they can't look. So let's say that you say, "Yeah, search my home." "Yeah, fine, come on in." And you remember, oh, the police are in the kitchen. And you're like, "Oh crap! My stash is in the corner cupboard." You can go in there and say, "Don't search that corner cupboard. You don't have my permission." Police can look everywhere else but that corner cupboard. So you can keep limiting consent. And is it suspicious? Like, absolutely. Is it enough to get a warrant? Generally, no. Right? Usually invoking your rights is not enough to get a warrant. Now, you can also revoke consent at any time. So let's say they're searching your kitchen and you're like, "Oh crap, the stash is in there." And you're just like, they're starting to head that way, and you say, "You know what? I withdraw consent." And as soon as you say, "I withdraw consent," police have to stop searching immediately. They can't continue through the drawer. They have to just walk away. All right? They cannot continue. If they continue past you saying, "I withdraw my consent," then it's an unreasonable search and seizure. All right, so kind of keep those in the back of your mind, and if you ever get asked to be searched, always say no. Always, always say no. Now, there are situational searches that are subject to a warrantless caveat. This includes private searches, so If your neighbor comes through your house, like just breaks into your house and like finds drugs and they call the police, well, the police didn't do it, your neighbor did. So we're going to allow it. Border searches. So generally at borders, they can be searched with near impunity. Inventory searches. This is if we tow a vehicle, we're going to go through the vehicle. Not to find, theoretically, not to find evidence of a crime, but to make sure that we document everything's in the vehicle. So that way when you get your car back, you can't say, yeah, but I also had a laptop in here and the laptop's missing. They're going to say, well, no, well, since we got it in, we looked through it and it wasn't there. But if they're looking through it and they find evidence, well, it can be used against you. Electronic eavesdropping, this is interesting. It includes lots of things in terms of where you are and whatnot. But also it invokes the FISA court and international calls, etc. And then open fields. So basically, if you own a lot of land, the chattel, the area immediately surrounding your home, is protected. But let's say you live on 57 acres of land. Your home is like on this little corner. That's protected. But the rest of the land isn't. Police officers can theoretically come on to like search your cornfields if they want to, right? And they can fly helicopters over your house if they want to like get a better view of what's in the corn, right? Like it's not just a cornfield to hide a pot field or something like that. So, and the idea here is you don't really have an expectation of privacy. People can come in, stumble in, whatever. If you have a fence, that changes the analysis a little bit, but not to an extreme degree. Now, that being said, this does implicate the plain view doctrine and the plain sweep doctrine. So just like the plain touch doctrine, if you see something while you're searching, it's out in plain view. So like you are in hot pursuit and you go into some like third party's home and that third party happens to have a mountain of cocaine sitting on their coffee table. Well, not only can you arrest the fugitive, but that was in plain view. You didn't search for it. You can arrest the homeowner for the cocaine. And then plain sweep, generally speaking, officers are permitted to do what's called a protective sweep once they enter a home. And all that is a very, very, very attenuated, very, very, very short search in which they just check rooms to make sure there's nobody hiding in the rooms. Right now, they're not supposed to search at this point. Again, things get very tricky, but they can just look around, make sure there's nobody in the room. But if they happen to look around and they look down and without opening drawers or anything along those lines, they see on your nightstand a pile of cocaine, that's part of the plain sweep. So even if you don't get consent or something like that, the fact that they saw it during their sweep, even though they have to you didn't give them permission to open cupboards or anything like that, they saw it as part of their sweep, it can be used against you. So let's transition into the Fifth Amendment dealing with confessions. Now, as you see on the screen, you can link to the Fifth Amendment to read the full thing. The part that we're concerned about with is dealing with confessions, right? So to protect individuals from self-incrimination, otherwise known as confessions, that are coerced or otherwise involuntary. So what we kind of mean by this is you can confess to the police if you really want to, like that's on you, like you make that decision, you make that decision. But the police cannot get a confession that they have coerced out of you or is otherwise made involuntary, right? Now, generally speaking, this only protects against communicative evidence, so evidence designed to communicate some kind of message in relation to your regard to crime, right? So let's say that you are mute, you can't speak. Well, if you write down a confession, that's communicative evidence, right? So again, something that's kind of unequivocally telling us that you're trying to communicate a message. Now, we kind of start a series of cases when we start with Twinning versus New Jersey. Um, and Twinning versus New Jersey kind of dealt with an involuntary confession. Um, Basically, what happens in Twinning is it's a criminal case. The judge gives jury instructions, and we'll talk about what those are when we get into a different unit, but gives jury instructions and basically tells the jury, hey, jury, because a man does not go upon the stand, you are not necessarily justified in drawing an inference of guilt. But you have a right to consider the fact that he does not go upon the stand where a direct accusation is made against him. So, what happens here? Basically, the jury just returns a guilty verdict. And there was a challenge, right? Twinning challenged this, and he said, when you said that they could, like, it doesn't, that you could consider the fact that I didn't go on the stand, that could be tantamount to an implied involuntary confession, right? And this, it is a denial of due process. In an 8-1 decision, the court ruled against Twinning, stating that the privilege of self-incrimination was, quote, not fundamental in due process of law, not an essential part of it. So, not a great outcome from Twinning, right? By today's standards, we would be shaking our boots, because today's standards, the judge can't say anything. In fact, the judge has to direct the jury. The defendant doesn't have to take the stand, and you cannot make any inferences from that fact. But again, this was 1908, so this is kind of showing us the evolution of due process and self-incrimination. Then we move into a 1936 case, Brown v. New Jersey. So this was an interesting and horrible case. Basically, this finally applied the Fifth Amendment to the states. This was a unanimous decision. So in this case, there were 3 black men who were arrested for murder of a white man. At trial, they were convicted solely on the basis of their confession, and they were sentenced to death. But here's the caveat. The police had coerced their confessions. The defendants had been tied to a tree, whipped, hanged by a rope 2 times, and told that the process would continue until they confessed. And although torture has been clearly used to elicit the confessions, the Mississippi Supreme Court said, okay, no, that's fine. Right? If they weren't guilty, they wouldn't have confessed. That being said, that year, the Supreme Court said no. U.S. Supreme Court said not gonna happen. Because I mean, think about this. It's unbelievably insane. So we fast forward in time a little bit further to the 1960s, right, during the criminal justice revolution. We have 2 really important cases that come down. The first is Escodoba, and the second is Miranda. So Escodoba, basically, this guy was arrested without a warrant and interrogated for approximately 15 hours. During this period, he made no statements to the police and was released after his attorney obtained a writ of habeas corpus, and we'll talk about what that means later, 11 days after the shooting that was being investigated. That being said, Escodoba was arrested for a second time and again taken to the police station for questioning. Shortly thereafter, Escodoba's attorney arrived at the station, but the police would not permit him to see his client. Both the attorney and Escodoba repeatedly requested to see each other, but both were continually denied. Escodoba was told that he could not see his attorney until the police had finished their questioning. Now, it's during the second period of this interrogation that Escodoba made certain incriminating statements which could have been construed as a voluntary confession of his crime. Ultimately, he was convicted and sentenced to 22 years in prison. That being said, Escodoba said, look, I was told by the police that I'd be permitted to go home if I gave my statement and would be granted immunity from prosecution. What happens is the Supreme Court eventually just grants certiorari and comes down with a ruling in favor of Escodoba. It was a 5-4 decision. And what the court noted were 5 pivotal factors in the interrogation that were problematic. 1, the investigation was no longer a general inquiry into an unsolved crime, but had begun to focus on a particular suspect. 2, the suspect had been taken into police custody and therefore was not allowed to leave. 3, the police carried out a process of interrogation that lent itself to eliciting incriminating statements. Right? The goal wasn't give us more information, it was we are trying to get a confession. 4, the suspect had been requested and had been denied the opportunity to consult with his lawyer. And then 5, the police had not effectively warned him of his absolute constitutional right to remain silent. So Escodoba basically says that an accused person now has the right to an attorney to be present during investigations. The 4 dissenting justices didn't like that decision. That being said, 2 years later, we have Miranda v. Arizona. So Miranda v. Arizona is actually an aggregate of basically 4 cases, right? So it's actually Miranda v. Arizona, Venera v. New York, Westover v. United States, and California v. Stewart. And so they kind of just compiled all these cases into one. And since Miranda was the first name of the first case, we've just called it Miranda, right? And you've probably heard of the Miranda warnings. So basically, in this case, all these people, the defendants in these cases, have been convicted on the basis that their confessions were made after extended questioning in which they had not been informed of the right to remain silent, kind of like we saw in Escodoba. In all 4 cases for the crimes that had been committed involved major felonies. So Miranda had been convicted of kidnapping and rape, Venera of robbery and first degree, Westover of bank robbery, and Stewart of robbery and first degree murder. They all confessed, right? And the convictions were overturned by the U.S. Supreme Court. And the U.S. Supreme Court, in their decision, articulated what we now know as the Miranda warnings or Miranda rights. So you see these on TV all the time. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to consult with a lawyer and to have the lawyer present during any questioning. If you cannot afford a lawyer, one will be appointed to you if you so desire. Do you have any questions? Do you understand? Right? From this, the Supreme Court said, look, this isn't necessarily a magical cocktail. Like, you don't have to read this verbatim, as long as you get the points across, right? Most officers actually carry a card in their pocket. And anytime they make an arrest, even though they have it memorized, they read the card, right? And they're making the arrest, they read the card. When they get the suspect to the station, they read the card again. When they start questioning him, they read the card again. So the person gets Mirandized several times. And the idea is, look, we're trying to kind of cover our backside so that we don't have big problems. We don't put together this big case, and it just kind of all fall apart. Now, that being said, you can still get Mirandized, still have your Miranda rights read to you, and still give an involuntary or coerced confession. So you might know you have the right to remain silent. But if police question you for, I don't know, 48 hours straight, and you're withheld food and water for 48 hours, and you're not allowed to sleep, but maybe take 15-minute breaks here and there, and then you finally break down and confess, we're almost always going to say, no, 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 that was coerced. Prosecution's going to say, well, they got Mirandized, they knew they had the right to remain silent, and then the defense is going to respond with, yeah, but the circumstances you created would undoubtedly always lead to a coerced confession. It was involuntary, right? The person was probably confessing to end the communication. So that being said, another piece of advice that I have for you is if you are ever in a situation where you have had the Miranda rights read to you, always, 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 always invoke the right to counsel and say nothing. Now, there's a couple of reasons here. Let's start with the say nothing part. Some people think that they can out-trick or out-fox the police, or they can talk their way out of trouble. I've never known somebody who's talked their way out of trouble with the police. The police have more information a lot of times than the individual does, right? Especially if there's co-conspirators or something like that. Denials might even, you can deny, but I wouldn't say anything. Just say nothing. But say that you want to invoke your right to remain silent, because they can keep questioning you even if you just sit there staring at them. They can keep questioning you. If you say, I want to remain silent, then the questioning has to stop. Now, why I say stay silent, but always ask for counsel, right? Always ask for an attorney, is because as soon as you ask for an attorney, all questioning has to stop and cannot continue until you are given an attorney. Now, if you invoke the right to remain silent, the questioning stops, but they can come back usually within like 24 or 48 hours and then start questioning you again. And you can keep saying, oh, I revoke, or I want to remain silent, and then they wait 48 hours and they come back, right? If they do that too much, then we're talking coerced or involuntary confession. But if you say, I want a lawyer, and we'll talk about what you have to say, but I want a lawyer, no questioning, no matter how long it's been, can continue until you get to talk to your lawyer and have your lawyer present. So always, if somebody reads your Miranda rights, immediately say, I want a lawyer, because they're not going to be able to ask you a single question. They can't make comments towards you. They can't say, well, you're obviously guilty. No, because if they do any of that, that's a violation of the Fifth Amendment, and anything you say following it is coerced or involuntary and is generally thrown out. Now, that being said, there is a caveat. When you invoke the right to a lawyer, or even the right to remain silent, but again, right to a lawyer is what you are always going to do. Be clear and unambiguous. So the Supreme Court has told us that if you want to invoke the right to counsel, you have to be clear in what you're saying, non-ambiguous. And what we mean by that is there is a big difference between I want a lawyer and should I get a lawyer? One will stop the questioning and get you a lawyer. The other, the police can just keep questioning away, right? because you weren't clear and unambiguous that you wanted a lawyer. You're saying, oh, I think I need a lawyer, or should I get a lawyer? What do you think? They can keep questioning you. You have to make a blank statement. I want a lawyer. Right? And I'll say it again. I want a lawyer. Not I think I need a lawyer, because again, you haven't asked for it. I want a lawyer. Right? It has to be clear and unambiguous. The thing I'll talk about next is the exclusionary rule. So this is my vein of research in my dissertation. The exclusionary rule basically prohibits the use of evidence or confessions obtained in violations of an individual's constitutional rights. Right? So evidence obtained via the Fourth Amendment, confessions obtained via the Fifth Amendment. There's something called fruit of the poisonous tree, which can also be excluded. So let's say that you are being tortured by police, and you confess to a series of murders, and they only think you've committed one murder, but you can confess to a series of murders. And you tell them where the bodies are buried and where the firearm used to kill them was. Well, they're going to go get that firearm and they're going to go get those bodies, right? But, and now here's the but. They tortured you, or they got an involuntary confession from you. The idea behind this here is the only reason that you told them that where the other bodies were buried or where the firearm was, whatever, is because of the involuntary confession. The police wouldn't have learned it if they didn't get the involuntary confession. So not only is the confession thrown out, but anything the police get from the confession. Now there are some exceptions and attenuation and things like that come into play, but anything that you say and then the police go and find because you said it also gets thrown out. Now there is what's called the good faith exception. So this is if officers believe an invalid warrant was actually valid or there was a clerical error. So for instance, you live in an apartment complex, right? And you meant to type apartment K, but instead your hand slipped over and you typed apartment J, but you thought you typed apartment K, right? And then the judge signs the warrant and you go execute this warrant. And the warrant says apartment J to the SWAT team or whomever. The SWAT team goes into apartment J. They were supposed to go into apartment K, but they go into apartment J. And in apartment J, they find, lo and behold, an unlicensed nuclear weapon. Guess what? That person who owned that weapon, who rented that apartment, is going to get charged with the nuclear weapon, and the nuclear weapon will come into evidence because it was good faith, right? The officers weren't trying to violate your rights. This was just an accident. Now, that being said, once we figure out the error, then the police are going to go get a new warrant and then go over to apartment K and search apartment K for whatever reason they were. So again, if you come to the wrong address because of a clerical error or something along those lines, but you're not trying to violate somebody's rights, like you're trying to go by the book, that's why you got the warrant, that's where we come from. Now, the purpose of the exclusionary rule is not to reward offenders by letting them off. It's to deter police misconduct, right? So we want to say to the police, you spend lots of time, lots of money, you dedicate your life to building some cases, like sometimes 2-3 years to build a case. But if you do it in a way that violates somebody's rights, the Constitution, we're throwing that out. Now, you may still go forward with trial and just not have all the evidence. That happens. But we're not allowing this evidence in. We're not allowing the confession in, or we're not allowing the physical evidence in, whatever. And the idea is police, if they do it once, they're not going to do it again, right? they're going to be extra certain that they don't make a typo. They're going to they're going to be extra certain that they get a warrant, that they do what they have to do so that their case doesn't get thrown out. Now, there's two cases in point, Weeks v. United States. So Weeks v. United States, this case is the case that essentially established the exclusionary rule in the United States. So England did have an exclusionary rule. If we think of King v. Rudd, there was an exclusionary rule articulated. Weeks v. United States was the first that said, yeah, exclusionary rule, cool. And then Mapp v. Ohio applied it to the states, right? So Weeks v. United States was a federal case. Mapp v. Ohio was the states. Mapp v. Ohio is really interesting. If you read the case, it's great. Like, she tells officers go away. They stand on her lawn for a long time. Then they come back and they say they have a warrant. And they show she grabs the warrant and she sticks the warrant in her bra. And it turns out that's a fake piece of paper. It's a really great case. And you know, they find evidence in the house and charge her with it, and ultimately the evidence is thrown out. They didn't have a warrant, they didn't have anything like that. Right? They violated this lady's rights. And the thing is, just because somebody is criminal, right, violating the law is criminal, that's how we define criminal, we don't want our police to be criminal. Right? Just because somebody else was criminal, like, and violated the law, Constitution is a law too. Right? We don't want you to violate the Constitution. Right? Two wrongs don't make a right. And that's kind of the prevailing theory here. Right? Two wrongs don't make a right. Now, that being said, the importance of the rights that we've kind of gone through cannot be overstated. So if you get a chance, check out this link or just Google the Innocence Project. I worked with the Innocence Project in law school. It's an amazing organization. And their goal is to get legitimately innocent people, usually exonerated through DNA testing, out of prison. They have gotten, if you look at the homepage, they have a tally of how many they've gotten out of prison who were legit, like factually innocent, who spent time in prison. They have gotten people off death row. They have gotten people out of life imprisonment. They've got people who've served 20, 30 years in prison, maintain their innocence, and finally DNA comes around in the 1990s, and now we're starting to be able to use it to exonerate prisoners. And what it tells us, if you read through the Innocence Project, is we don't do a good job of getting guilty people. So the vast majority of the people in prison are guilty, absolutely. But there are quite a few people who are legitimately innocent. And we know now, kind of beyond a shadow of a doubt, we have executed innocent people. That's something to think about. And that's, again, part of the reason these rights are so important is because a lot of the people who eventually get exonerated confessed. Right, but they confessed because it was coercion or it was otherwise involuntary. Something happened and they just confessed. Right? The police said, oh, if you just tell us you did it, you can go home. Well, then I'm going to tell you I did it, so I can go home. Well, they don't let you go home. So we know there are a lot of people in prison that are innocent. Right now, the Innocence Project is dealing with DNA, but most cases don't have DNA. Right? For instance, like grocery store robberies, we don't deal with DNA. Maybe fingerprints and fingerprint evidence is a whole other story. Take my criminal investigation class if you want to learn about all the problems with fingerprints. But I mean, generally speaking, like the person isn't like spitting onto the cashier or something like that. So we know that, look, if DNA is exonerating this and DNA evidence is only available in really very few cases, and it's exonerating people left and right, then we have a pretty good reason to believe that in non-DNA cases, there's a lot of people in prison or on death row or who have been executed that should not have been. So that being said, next class we're going to look at police conduct and integrity. Thank you for watching, and if you have any questions, always feel free to reach out to me.